All righty, so welcome to the consultation. My name is Christina Jimenez with the Jimenez Law Firm, and today I have some special guests. Why don't you all introduce yourselves, please? Go ahead.
My name is Greta. I'm one of Miss Jimenez's paralegals. Been with her for almost 9 years now.
You're all of our paralegals, not just mine.
Yes.
Thank you, though.
You share me.
I do have to share you. Netherlene, go ahead.
My name is Naideline Villarreal, and I'm also a paralegal here at the Jimenez Law Firm, and I've been with the firm for almost 3 years.
And my name is James. I'm an attorney here at the Jimenez Law Firm.
All right, awesome. Sorry about that. All right, so every Friday at noon, we come together. We have different members of our team. Sometimes we have special guests. We have family members, past clients. And essentially what we do is we talk about complex family law issues. Sometimes we sprinkle in a little bit of criminal defense because family law and criminal defense oftentimes, unfortunately, go hand in hand. And so I tell everyone at the onset of this Facebook Live event that you should not take this as legal advice. Okay, so what we're doing is we're going through different legal fact patterns, and as we're going through them, you will see when we're talking about them that the slightest little nuance in a fact pattern can change our entire opinion about what we think a court might do, or what we may do, or what opposing counsel would do. And so it is very, very important that you take this and you potentially use it to have a further discussion with your attorney of your choosing that knows your specific fact pattern, because one little thing can change everything. Okay. And so we do, like I said, do this every Friday at noon. We have a YouTube channel. We're on Twitter, Facebook, TikTok, Insta, I don't know, wherever there's a social media platform. Our boy Keon is making sure that you can find us if you need us. Our hope is that we're giving a little bit of information so that it will help people and guide you guys through this really sometimes difficult and frustrating process. So with that being said, James, do you want to take us away on the first question?
Absolutely. Absolutely. So we got number one, numero uno, how to modify a divorce decree and what average costs to lower to draft the modification. I have to get my son's medical insurance through my employer because my divorce decree said specifically that medical insurance has to get through my employer. When I remarried, I have the option to get medical insurance through my husband's employer. However, due to the specific language in the post degree, I am obligated to get medical insurance through my employer for my son. I'd like to make a modification to allow me to get his medical insurance, not only from my employer, but from any other source. Where can I get the help to come up with the correct paperwork for this action? Greta, what do you think?
The place would be to for sure hire an attorney. That's where I would get the paperwork from, first of all. Average cost, I guess it depends on where you are and who you hire. There's that saying that Miss Jimenez always likes to use, you get what you pay for. And that is definitely true sometimes. But as far as, her needing a modification, I don't know. I mean, I guess we would need to really see what the order looks like. Because I know we've had cases like this in the past where, mom was ordered to maintain health insurance, but her husband was actually covering the kids. So I guess it really just depends on how the order is worded.
Yeah, I mean, for sure. I would think that the language, that would be odd if it specifically stated that mom has to carry it through through her employer. But I guess it could say that. And so this is definitely one of those scenarios where mom is going to need to sit down, take her decree to an attorney, have the attorney evaluate it. And then from there, it should be a relatively simple and inexpensive modification, right? So a lot of times when I'm doing consultations, I will say, listen, this process or this issue is really something that you could maybe hire a younger attorney or a less expensive attorney, because it's going to be maybe a little bit easier to get it done, right? More cost effective. I would think that this would be something, if I were the respondent on this, I would say, send me over an agreed order and we'll sign it and let's get this thing done. Because at the end of the day, we just care about the insurance, right? Maybe dad, I don't know why dad would have a problem with it. That would be silly to me, right? Unless it's like a really bad health insurance plan, and maybe mom's plan is better, but I don't think judge would care about that. I think judge would say, just get the child on health insurance and be done with it. So cool, easy peasy. Next question. Nathalie, you want to read it for me?
Yes, ma'am. Do we have to provide financial statements of the company to the other party? C corporation payment of child support is made. I pay child support and medical insurance for my son, never late. I am a partner in a corporation, C corporation for financial reasons, the money stays in the company. Can the court force me to disclose financial information? I know it is illegal and cannot force disclosure. My ex is looking for any reason to get more money for child support.
Gretchen, we've had this come up in a case before. So talk to me. What do you think?
I mean, I guess first of all, is it an open case even? I mean, if it's a pending case, then we do have to disclose certain financial documents and disclosures. That that's something new that Texas has started. I think a court can compel you. I mean, if you're receiving funds from this corporation, that would be calculated into child support, wouldn't it?
I don't know. So we've had this issue before where we tried to subpoena a separate entity. So we've had a case where the business was put in the girlfriend's name, right? And we knew that it was really dad that was operating the business, and it was really his business because it was like a trucking company or something like that. But he put the business in the girlfriend's name, and we had attempted to subpoena the girlfriend's records. And the girlfriend hired an attorney for her company and filed a motion to quash that subpoena, basically arguing that the boyfriend, that the father didn't have any interest in that corporation, and therefore we should not be, allowed to get the documents. And so we had to have a short hearing and explain why we believe that maybe girlfriend and dad were perpetuating some sort of a fraud to avoid having to pay child support. And in that particular case, the judge did allow us to obtain those records from that third party company, right? I mean, I don't think that the proper method would be to go through discovery. I think that with discovery, he could argue, it's not my business, or it's a C corp. Those are not my documents. I don't have the right to disclose those. But I think that if you were to set a deposition for, the partners of that corporation, or send a subpoena over to them, I think they would have to turn it over. Yeah. And it's funny because he kind of mentions that the money's staying in the business for business reasons, but I mean,
which was pretty close to the case that we had. And if I remember correctly, all of the money was calculated towards child support, and he was actually maxed out, I believe.
And so I don't know. I want to say in that case, it was an LLC. And so the difference here is the fact that it's a C corp, and he's a shareholder in that corporation. And so he has an ownership interest in the shares. I don't know how you make that link to, or that jump to that's his income, especially, did he say that he's a partner? Yeah, he's a partner. I don't know how you make that link to that's his money. I think you'd have to look at the partnership agreement. You'd have to look at why the money's staying in the company. I don't know. I think
I gotta ask. So remember in biz orgs when they talked about C corps and how you can structure it so you pay yourself out of the money from the company. So what I'm thinking is happening is that OP has figured she's not paying herself enough because she doesn't want to pay child support, right?
Girl or boy, mom or dad? I think it's dad, right? Or I guess it doesn't say.
It doesn't.
Well, good for you empowering women.
Hey,
James, go on ahead.
Who runs the world?
That's right.
Right. Continue. My apologies.
But so I think that's what's going on. And that's why he's like, hey, she's making all this money from the company, but she's paying herself, let's say, minimum wage. That's an interesting question, because in a C corp, I think you can do so.
No, absolutely. I mean, she's on payroll from the corporation, right? So she's getting a W-2 from the corporation. And that's kind of where I was going to go with it, is I think the better option or argument would be not so much that income has to be imputed on mom, who's obligated to pay support in this case, but it's an argument of intentional underemployment. Right. So her company is making all this money and they have $500,000 sitting in the bank. Then mom has the ability to potentially get maxed out on this. I think that's a stronger argument. So yeah, that's tricky. Now, I think that it really does, and with any sort of child custody, child support, any of that, it's all very fact intensive, right? And so if in this case, mom were to get in there and testify like, yes, we have $500,000 in the bank, but we also owe the IRS, $350,000 for this tax year. Or we're planning on buying a building so that we can eventually, get more assets and make more income. I think that if a court were to listen to the testimony and have this idea that, mom is really on the up and up and she's not trying to commit any sort of fraud or not pay support pursuant to the guidelines, there's a fighting chance. But in our other case, we were able to kind of formulate and explain to the judge, like, look, judge, there's some shady stuff going on here, right? And since there was shady stuff going on in that case, I think the judge was more like, okay, here's your number because we don't think you're being honest. So, yeah, that was a good question. Good question. Okay, next question. Gretchen, you want to read?
Sure. Okay, what is a reasonable amount and conditions for purge given? Owes $7,000 in arrears, and this is second contempt. NCP was appointed a court lawyer. However, not sure how they qualified since there is proof they consistently pay for bi-monthly $600 to $1,000 air travel for visitation with our child and can afford that, but yet not pay for child support. I'd like to know what likely purge amount and conditions is to be set at the hearing. This is the second contempt within 2 years, and this time was initiated by the state, not me. Unfortunately, I feel unless there are consequences like jail, they will never actually follow the court order.
Okay, so I'll take this one. There's a couple of issues here. So your first issue is a court-appointed attorney. So in child custody cases, in child support modification cases, all of that stuff, the the probability of you getting a court-appointed attorney is slim to none. And I'm being very careful in my language because we were actually learning about this past week at our Lunch and Learn. Maybe there is a code provision that would potentially allow a court-appointed attorney, but I've never seen it done in 14 years in any other case other than a CPS case where they're trying to terminate your rights, or a case where they're trying to put you in jail because you're violating the order. Okay. And so when you find yourself in either one of those situations, you have the ability to request that the court appoint an attorney to you. Okay. What you're going to have to do is you're going to have to file what we call an indigency affidavit, or you're going to have to testify, and you're going to have to swear under oath that, you know, here's my income and here's all of my expenses. And then from there, if the court feels like you are indigent and that you don't have the ability to hire a private attorney, then the court can at that point appoint an attorney. And that attorney is appointed solely for the purpose, in this particular case, of defending you against a contempt proceeding to keep you out of jail. Okay. If the court learns, like through the course of that hearing, that you are not in fact indigent, I would say, I don't know, I guess technically what the judge would do. I would presume that they would assess court costs and fees against you. And maybe hold you in contempt of court for not being truthful when you're swearing to your income and expenses under oath. So don't do it. Just be honest and hire an attorney if you can potentially afford it. Now, this idea that he's paying $600 to $1,000 for air travel visitation, I mean, that's an expense. And I think that the judge would probably say, I don't know, that's a reasonable, necessary living expense. I don't think he gets dinged for that. As long as everything else lines up. So she's talking about a purge amount, which I think is what she's referring to is a lot of times what will happen, especially when the state files an enforcement against somebody, is when you show up to court, the state will say, okay, can you pay X number of dollars? And if so, we're not going to put you in jail, right? Or we're only going to put you on probation. And so I don't know what a reasonable purge, how much does he owe? $7,000? Honestly, that should be up to mom. Assuming that it's mom that it has custody, right? It should be up to mom what the purge amount is. And if mom wanted to, she could say, I don't want a purge amount. I want him to go to jail. And I want him to go to jail for up to the 6 months, because that's what happens when you're in violation of an order, up to 6 months per violation, but typically it runs concurrently. And so I don't know, if she were my client, I would say, okay, like, let's put him in jail.
Oh, James, you look bothered.
And I think this is a wonderful opportunity for me to bring up something I found on TikTok.
Oh.
And I don't have a TikTok. I just happened to be scrolling after one of the lovely TikToks CJ posted in the group chat. So, and it was interesting because it was a young woman, and she said that she took her son's father off of child support. And it was like, why would I take him off of child support? Let's do something to help him help us. And I was like, wait a second, what's going on here? So she ended up helping him get his CDL. And it's this long, beautiful story about how once she took him off and he didn't have that obligation, he was able to better his life. And then he went on to help better the lives of his child and the mother of the child. All that to say, throwing your child's father in jail. I mean, there may be a time and a place. There may be a time and a place, and I'm not one to disagree with the wise, Christina Jimenez. However, that is something you're definitely going to want to consider, right?
I mean, especially for $7,000, I think I can understand if it was like, $30,000, $40,000. Okay, maybe then. But $7,000, I mean, you put him in jail, he's not working, he can't pay his child support, then what are you going to do?
Come
So,
on,
but
Greta.
hold on though, hold on. So this is the second time in 2 years that she's taking him back, or the state's taking him back. And he owes $7,000. I mean, we don't know what his child support obligation is, but my opinion is if they're not paying child support, then who cares if they're in jail? Because they're not paying child support anyway. I'm not getting anything anyway. So put them in jail. So when they get out, they'll pay. James, you're about to find out how expensive these kids are. Like,
I believe it. I believe
your
it 100%.
opinion will change.
I believe it. But this brother, I mean, assuming he's brother. So this brother is bi-monthly paying $600 to $1,000 to exercise visits. So he wants to be in this kiddo's life. So if you will, with me, join together, hands open, hearts available to give this. I'm just kidding. But I understand, CJ. I mean, I think there's certainly a time and a place. And if he's not getting the hint, maybe, maybe the clink is the right place for him. But, bad stuff happens in there. I'm telling you.
Well, so, the other thing that I will say, and looking at it from the other perspective of if I represented, did y'all see Daniel's statement? Are we talking about the first purge election year, the forever purge, or anarchy? If I'm involved, it's anarchy, Daniel. But looking at it from Dad's perspective, and I don't know like what the circumstances were that he has to start exercising visitation and flying his kiddos, but that is a thing. If you have to pay, or let's say hypothetically speaking, mom had relocated with the kids, and now dad has to incur additional expenses to travel to see his children, he can actually request that be offset from his support, right? And so we've had a lot of success in that. And it's kind of a little bit goofy the way that you have to argue it, but the argument becomes, okay, a round trip flight, each month for my kids is going to be $500. And I anticipate that I'm going to see them at least once a month. So I want to take that $6,000 and I want to deduct that from what my child support obligation would otherwise be. And so, I think that's, again, I don't know how much this guy's paying, but if he's spending that much on his visitation, depending on why he moved, if he moved or if they moved or whatever, that's something that I would probably try to modify to reduce his support so that he could be an active father. He wouldn't have to go to jail for not paying his child support. So I can do both. It just depends on who hires me.
That's real. That's real.
So, but yeah, I mean, to me, if a dad's not paying or a mom's not paying and there's no good reason for it, kids, I mean, they need a lot of love, but they also need food and shelter and clothes, and that stuff costs a lot of money. So you got to take care of that. So
it does.
Yes. All right. Who wants to read the next question? James?
Should I be paying child support before anything is established in court? Okay. We are unmarried, but my name is on the birth certificate. Should I be giving her child support while I file my paperwork for paternity and mediation? She has also given me limited time with our daughter to just a few hours every other week. Natalie, what you think?
So there's a lot of factors that go into this too. First, I would say that is there any doubt in paternity would probably be one of my first questions. And if there is, we should probably proceed with the genetic test. And then also you would have to know, you have to know when you separated. When did you guys separate? How long has it been since the time you separated? And then also how much money are you making, like yearly? And ultimately, I would say, yes, you should be paying her child support, even if there's no order in place. You should be at least helping provide for your child or this child. You should be helping provide for this child. And like I'm saying, it depends on how much you make yearly. Like if you're making $200,000 a year, I would say you probably shouldn't just be paying $50 a month. And I actually had one case where I had dad hired us because he wanted to get an order in place to pay child support. He actually said, I want to avoid arrears. I want to avoid any problems in the future. And I want to start paying child support. So, yeah.
So if he has any doubt that this kiddo's not biologically his, I don't know that I would tell him to give her money. Because what if he gives it to her and then it's not his and then he's out, $5,000, $10,000?
So how does that work? Like, have you ever had that come up where paternity is, hasn't been established, dad isn't sure, but, doesn't really have any doubts. And then at some point it comes out that he's not the father, but he's been paying all of this money. Like, is there any way to recover that?
Cool. I would say that he is SOL. So we actually, a little bit different because it was established by a court order. So yes, there was a court order where dad had been obligated to pay child support for like 14 years. And then something happens where like the mom's sister says, I don't think that this kiddo is yours. And so he goes and he does a genetic screen. And I think we filed for a termination at that point because he was like, she's not my daughter. And I don't want to have to pay child support. I don't want to be obligated anymore. And in that case, the judge granted the termination, didn't order future support, but all that money, it was long gone.
Oh, that is awful.
And I don't know, maybe there's like a civil suit or something that you could file. But I didn't research that. And I don't think like off the top of my head that that's a thing. So yeah. And in that case, like in this case, prior to an order, if he's giving this woman money and it turns out that it's not his child, I think it's just a gift. It's just, you shouldn't have given it to her unless you knew 100% it was your kiddo. So
that's scary.
Yeah. Yeah. And what I would probably do is I would maybe tell him, run a child support calculation. So how do we calculate child support, Gretchen?
Fees product.
Excellent word. So what we're going to do is we're going to look at the gross income of the NCP, the non-custodial parent, right? And then let's say hypothetically that you make, $100,000 a year, we divide that by 12, and whatever that gross monthly income is, you can actually go online to the Office of the Attorney General's website, and you can plug in your gross monthly income. And then you can plug in the cost of your health insurance, and it'll get you an accurate idea of what you're going to be paying in child support. Now, keep in mind, it's not just what you're making from your W-2s, right? If you have rental income, if you have a side hustle, like whatever it is that you're doing, you have to include all of that stuff on your gross monthly income. And so if he came to me and he did a consultation, what I would say is, let me run the calculation. Boom, here's your calculation. I want you to start putting $1,500 a month into a savings account. And if, Lord forbid, in 3 months, we find out that this kiddo is not yours, well, you have some play money, right? If we find out that it is yours, then when they confirm that judgment, because they will confirm the judgment, then you can just take that money and pay it and then not have to worry about interest or payments or any of that crap. And so he said, did he say just a few hours every other week? He doesn't need a court order to go down and get a genetic test. We've done that before, right? pick up the kiddo for a visit, go down, get a genetic test. And then when he does that, if he finds out definitively, yes, this is my biological daughter, then Adeline, you're right, start paying. That way, we don't have to worry about the judgment when we go to a hearing. So,
this one's tough.
Yeah.
Additionally, Maury is retiring. Did y'all see that?
No,
I didn't. Yeah. After all these years, he's retiring. So I mean, maybe he'll end up on the anniversary episode. We'll see.
Guys, I just saw something on this freaking question that I missed. And that is, his name is on the birth certificate. So he's the acknowledged father.
And how long is it after you find out? Is it 2 years after you find out, like you have suspicion or cause to think the child is not yours to do genetic testing?
I think that it's 1 year or prior to a court proceeding. I think it's the rule. But I guess let's talk about that. So a lot of times people just say, I'm on the birth certificate. Really what that means is that when the child was born at the hospital, you signed what we called an acknowledgement of paternity. Okay. So an acknowledgement of paternity is a legal document where you're basically representing and stating under oath that this kiddo is mine. And it has the same legal consequence as an adjudication. And so once you sign that document, you're pretty much on the hook for that kiddo. There's some ways that you can potentially wiggle out of it, but you're the legal father. And so if you have even the slightest idea that this child may not be yours, don't sign the AOP, please. Just do me a favor. And it's not going to be a great birthday for your kiddo, like literal birthday, but it'll save you some headaches in the future. If you sign it and if we find out it's not your biological kiddo, there's ways to potentially get out of it, but it's not easy. It's going to cost you a lot of money to do that. So don't sign it. Better bet is do the genetic test. And then once you know it's yours, then we go and do all that other stuff. So nobody cares that he's only getting limited time with the daughter. They're just like, whatever.
I mean, I care.
Yeah,
I care.
Because you can tell he wants to be involved if he's mentioning it.
All right. And here's the other thing. So I have had dads who will say, I signed the AOP, or I know that there is a chance that this kiddo is not mine and I don't want a genetic test. This child's mine, no matter what DNA says. And so they'll waive that. That's a very admirable decision to make. And so, you'll need to talk to an attorney and kind of walk through all of that mental and psychological and spiritual crap that comes with it, because that's a heavy decision.
It is. We recently had one like that.
I don't remember, Greta. Yeah. You're like, you did. We did. So, yeah, those are tough situations. So next question. Who wants to read it?
I can read it.
Go for it.
What can my husband do if it states in his divorce decree that he gets to claim his son on his taxes and his mother claimed him? So my husband's divorce decree states that he gets to claim his son on his taxes every year, and that is why his child support is more every month. His mother claimed him this year without our knowledge.
James, what say you?
Okay, this is a tough situation. I had an agreement, and looks like someone went back on it. So with children, you can both claim them, but not on the same years. So sometimes we'll do it to where you alternate years, but looks like he has the unequivocal right to claim the kid. and mom's not having it. So what you'd have to do is you'd have to submit that divorce decree. You'd have to submit that divorce decree. I'm not a tax attorney, but I know that the IRS, they do have a form that you would attach it with. And then once you send that, and I'm assuming you all found out because your tax return got kicked back for claiming the dependent that had already been claimed, right? So under those circumstances, you would get that form from the IRS website. I don't know the form name, but it's on there. And then you would get that divorce decree so that you can evidence that indeed you are the one that's supposed to be claiming the child.
So let me interject real quick, though, James, because I think it would depend on what dad's visitation is, because pursuant to the at least it's my understanding of the tax code, and I'm not a tax attorney, disclaimer, but I think it's whoever has actual possession of the kiddo for 51% of the time or more would have the right to claim the kiddo as a dependent. And so if mom has the kiddo pursuant to the tax code, mom's going to trump dad, even if they had that agreement. And even if he produces that agreed final decree of divorce, I don't think that the IRS is going to care. Now, what he could do is he could do what you're saying and file a motion for enforcement in district court, and then basically say, here's the order. This is what she was supposed to do. She didn't. Now she gets to potentially go to jail, right? So I don't know that we can submit it to the IRS. I don't think that flies, at least. But again, I'm not a freaking tax attorney, so I would say talk to a tax attorney, talk to your CPA, and then see what they say.
They included that, she needed to execute that. I think it's form 8332 is what we have them sign that, and it specifies, in all years, and it specifies even in odd years as to who claims the kids when. So, I mean, if maybe that language is in there, maybe you can compel her to sign that.
Right, and there's an additional, I think you may even be speaking about the same form that mom waives her right to claim the kiddo on her tax return. Same form.
So. I'm pretty sure it's the same.
So that's interesting, because if you're saying, James, like we have the decree and she executed that form, I don't know what the IRS would do. Maybe they would do something with it if he had that form. I know that those forms can be rescinded, so I would suspect that it's worth a shot. If the IRS won't do anything with it, then backup plan is file a motion for enforcement in district court. And I would also probably file a motion to modify to reduce my support, because he's saying that he's paying extra each month in exchange for this. So that's kind of crappy. Yeah, so I would file a motion to modify and say, Judge, if she's going to do this and she's going to get away with it, then I want my child support reduced because I'm paying extra for no reason, which that's kind of silly to me that he would have agreed to that, but I guess.
Maybe he gets a fat return.
Maybe, but kind of silly. All right, anything else on that question?
Oh, the other thing, file early, early bird gets the worm,
Quite literally in this case. Yeah, so I guess that's kind of the thing about when this happens. Typically what will happen is when you claim a kiddo as a dependent and they process the paperwork, the first person who files and claims that kiddo as a dependent gets to claim him as a dependent. And if the second person comes in, then they reject that and they say, nope, this child's already been claimed. You don't get your money, they do. Now, if you were supposed to be the rightful person to claim this kiddo as a dependent, then what you do is you file a paper return, you mail it in, and it sucks because it's going to take longer to process, but you mail it in, then the IRS flags it. And they're going to say, all right, who legally should have had the right to do this, right? And then if maybe mom filed and took the return and she wasn't supposed to, they're going to do a chargeback. Mom has to pay, and then you'll get your money and it'll work itself out. But it can take months. I mean, I've had people like 8-9 months and they're still waiting, and they have to file multiple things. It's kind of just like a big mess. So yeah, but good advice, sound advice. Early bird gets the worm. Okay, next question. I will read it. So, can I be forced to pay retroactive child support if no order was in place for 16 years since our divorce? My ex-wife is going after me for 16 years of back child support. There is currently no order in place for back support. A current order has been in place since 11/1/21. I'm up to date on that and have been paying for it, even though my daughter doesn't live with her mother. So, Adeline, what do you think?
So yeah, I have the same reaction about the whole thing about the child not living with the mother. That's a little odd. But if there's an order in place from November 1st of 2021 and there's no arrears listed on that order supersedes anything that happened prior to that order. So if like you're not ordered to pay arrears on that order, assuming it's a final order, yeah, I don't see why or how she could do that.
Well, I bet you that one from 11/1/21 is just temporary. $20 is just temporary. So she's still trying to litigate the 16 years of back support.
Oh, that's going to be nasty. But I mean, if he has possession of the child, maybe, he can get a credit for, however long he's had. I think it's a daughter.
I don't think he has the daughter. I think kiddo is living with like a family member, not with mom.
True.
But yeah, you still owe, buddy.
Yep.
Get him for child support when they were. I'm confused a little bit.
What are you confused about?
Right. So she says was in place 16 years since our divorce. Right. Okay.
So if there's a divorce, maybe there's an order for child support, I would assume.
Yeah.
Yeah.
So, okay. Can I be forced to pay retroactive child support if no order was in place for 16 years since our divorce?
So then no.
Well, but did they not have the kiddo at the time of divorce? Maybe the child was born after, like maybe they hooked up again after the divorce was final and then the child was born?
Getting spicy.
Yeah, I mean, it's been known to happen. So here's why we're confused and why this question isn't making sense. So anytime you have a child that is born of the marriage, during the marriage, then your final decree must include conservatorship or SAPSA provisions for that child. And that was an excellent catch. Now that I didn't even see that. And so even if she's pregnant, like if your wife is pregnant while you are going through divorce, I've had one judge in 14 years grant a divorce while the mother was pregnant, which I didn't necessarily think was proper or okay, but that's what the judge did. So, when judges do that, you just have to say, okay. And so typically they will say we have to wait until after the child's born. And then once the child's born, if there's any issues pertaining to paternity, we'll deal with all of that craziness. And then they'll lay down some orders for child support. And so that's what's strange about the question. If you guys were divorced and at the time of divorce, your son was born, son was born, and there was nothing in that order with regard to your obligation to pay support, I think she's toast. I don't think she can do it. But if the child was born after you guys got divorced, and then you guys never went to court for that child, What do you think, Madeline?
Yep, I think he's gonna have to pay a lot of arrears.
Yeah. Yeah, I do too. So the presumption on back child support is 4 years, right? It's presumed to be in the child's best interest that dad has to pay 4 years. However, the courts have the ability to go past that. They also have the ability to say less than that, right? It's discretionary. And so in this particular case, and there's different things that judges look at, right? They look at, okay, did dad know that this was his kiddo? They're going to look at, did mom hide this child from dad? Had dad been providing any sort of support? Had dad tried to provide support and mom rejected it? Did mom, tell him that it wasn't really his kid, and so he didn't have a realistic idea that it was his child? All sorts of different factors that the court can consider to determine whether or not it's in the child's best interest to have that parent pay retro support. They're also going to look at how is this going to affect dad, right? If we put a freaking $80,000 judgment on him for back support, is that fair? Is it equitable? Is that something that we should really do? And all of that's going to depend on the fact pattern, right? If it's one of these things where for 16 years, mom has been begging him to help with the kiddo and dad's just like, F you, I'm not doing anything. And mom hasn't been able to hire an attorney for 16 years because maybe she has some sort of a disability of sorts. I don't know. I think judges might say, yeah, I'm going to go back 16 years. But if mom was like, F you don't get to see your kid, he's not even yours, and now she's trying to hit him up, that's not going to go well for mom. So can I be forced to pay retroactive support? Yes, you can be forced. Will you? I don't know. You need to go talk to a lawyer and tell them your story. So, all right, next question. Who wants to read?
I'll take it.
Go for it.
My name is still on the deed to the house that my ex resides in. Our divorce was uncontested. What does this mean for me? When my ex and I divorced, he forgot that my name was on the deed to our house. I filed for divorce and didn't contest any property or custody issues at that time. My name is still currently on the deed, not the mortgage though, and he is trying to apply for a home equity loan. This is when he was told my name was on the deed and they should have to, they would have to contact me.
I mean, he was awarded the property in the decree. She waived all of her rights. And so I'd say, don't be an asshole and just sign the deed over because it's not yours, right? I mean, it seems like maybe she's trying to get tricky and they're like, oh, well, my name's still on the deed, and so I want some interest in it. If in the divorce decree it was awarded to husband, then that property is his, right? And a lot of times, was this like a pro se divorce thing?
I'm thinking so.
Yeah. So a lot of times on these pro se forms that people fill out when they don't have lawyers, it doesn't have the requisite language to compel somebody to sign the deed, right? Like we typically will include order language where we say it is ordered that wife needs to appear on this date at this time at this location and execute this document, right? And if mom doesn't do that or wife doesn't do that, we get to put her in jail or request that the whole court hold her in contempt or pay attorney's fees or whatever, right? And so I would presume that that didn't come up in this divorce decree. But I think it's a simple fix. I think that husband could file a motion to compel signature of a document and basically say, here's my decree. I've asked her to sign this. She's not signing it. And I want her to pay my attorney's fees and I want her to sign it. I think judge would do that. We've done that before. As a matter of fact, Mr. Sarabia, I think, has done that before, if I recall. So we, just sign it. Don't make things more difficult. James, what say you?
I agree 100%, but from the tricky side, trying to gain some leverage because it looks like maybe she's upset. I don't know. does she have any room for leverage here? Because the language wasn't included. And hey, it may be easier to just pay me versus hiring an attorney. And
it depends on what the decree says. So, and this is the problem that I have with these pro se divorce documents. So we had a case where they had done one of those little forms, a husband and wife, they were going through this divorce on their own, and they finalized the divorce, but they had a trailer and a lot that was in both of their names. And in the decree, they didn't specifically address the trailer and the lot. It was like they checked all furniture, furnishings, vehicles, and they wrote out the names of the vehicles, and then it was like bank accounts, etc. But for whatever reason, they didn't include the trailer and the lot. And so fast forward like 4 years after the divorce, wife has been living in the trailer, been paying for the trailer, paying for the lot, and then husband comes in to try to file a post-dissolution division of property, and basically argued, look, we had this asset at the time of divorce, and we didn't divide it, and now I want my half. And so that's a thing if they didn't specify that the house was to be divided, right? It sounds to me like they probably did some sort of a global waiver, like all property in husband's possession, all property in wife's possession. But if there's any technicality on that language, she might be able to say, I want a post-dissolution division of property and argue for half of that house. So, yeah, maybe she should be an asshole.
You know, people want to know their options, right?
That's true. Yeah. I mean, I would want to look at the decree and see what it says. And then obviously the other things, anytime we're making these types of decisions, we're always doing a cost benefit analysis, right? And so we would want to see, okay, you know, at the time of divorce, was there any equity? What are the costs of, you know, how much is it going to cost you in attorney's fees to be able to potentially recover? You know, do you really want to kick your kids out on the street? Like all sorts of those types of considerations that have to be made. So, but yeah, if it was a global waiver of all your property, then sign it and save yourself the headache. Yeah. What are you thinking, James?
Agreed. It's just interesting because I know we are particular about the language in the order, and it's interesting.
Yeah.
It's interesting.
Well, and that's the problem. So I say, if you're getting a divorce and you don't have children and you don't have property, then use those forms, right? I think that's what they're designed for. And I think for the most part, you can probably get away with it, right? But if you have property or if you have kiddos, it's the language that's in there, they try to break it down as simply as they can, but it's still legal jargon and you have no idea what any of that means. And you're going through and you're checking boxes and you end up having to pay lawyers twice as much to fix that mistake than if you had just hired them in the first place to get it done right. So,
I mean, especially on an uncontested divorce, I mean, sometimes we can get those done for fairly inexpensive and you know, as quickly as permitted by law, but I don't think I would ever use one of those pro se documents. They're scary.
They are. And like this husband may be in for a crazy surprise if it wasn't done correctly. And that's not, it's just the uncertainty of all of it. That's kind of crazy. James or Greta, will you ask question 10, please?
Sure. How can I ask the judge to expedite the divorce? I need the final divorce decree to send to immigration as soon as possible. The court has already accepted the signed MSA and the judgment sheet. Is there any way to ask the judge to sign on divorce as soon as possible? I need the divorce decree immediately.
Okay, I'll take this one, but it's kind of like what you said. I mean, you got 60 days. I mean, so those 60 days are going to be those 60 days. No matter your own personal needs. The immigration consequences, that's actually something I'm not extremely familiar about. But what you can do if that 60 days has elapsed, reach out to your attorney. Hopefully they have a good relationship with the court coordinator. Apart from that, you may be out of luck. Exercise patience, speak to your immigration attorney, but there's going to be the required 60 days, no matter what your situation, unfortunately.
So there is an exception if there's family violence. So you can file a request to expedite if there's family violence, but he didn't say anything about that. The other thing that I would probably do, I don't know if, wife or whatever is dragging her feet or her lawyer is we would draft the decree and then we'd file a motion in our judgment and get a hearing scheduled on it as quick as we could, right? That way we can try to get it signed faster. And that's at that point, we're at the mercy of the court. And like you said, James, we'd call the coordinator and, maybe talk to opposing counsel. Hey, can we please get this thing entered? This is very important to us. I would have said that if I had, repped them at the mediation, I would put something into the effect of because I know that there's immigration issues, I would probably have said the final decree must be entered within 10 days or else wife has to pay X number of dollars in attorney's fees, or put some sort of punitive consequence on the other side to make sure that that thing was signed and entered and there wasn't any delay. And those are the things that you kind of have to think about when you're in mediation. At our firm, anytime we're scheduling something for mediation, we always have what we call a pre-mediation meeting. And typically that's done about a month or so prior to mediation. And we go through the wish list for the client, right? And we say, okay, what's the most important factors to you? We type out detailed notes. The paralegal will sit down and put an exhibit together to the mediated settlement agreement. And then if needed, we'll have another meeting with the client a week or so before mediation, because a lot of times what happens is, attorneys will show up to mediation with their client. They try to figure all this stuff out while you're there. And then you miss little things like this, and then you have problems, right? And the other thing is I don't want my clients making life-altering decisions on the fly. I want them to have a long time to think about it, to talk about it, to pray on it. And then when we come back, hopefully the right decision has been made and everybody's, calm, cool, and collected while we're in mediation. So, I would say file a motion to enter, try to get it signed, and then go from there. So with that being said, we are almost at our 1 hour block. And so as we stated at the onset, as I stated in the middle, I'll say it again at the end. Do not accept any of this as legal advice. So don't accept this as legal advice. This is merely information for us to share with you, to provide you little nuggets of info that potentially you can discuss with your attorney of your choosing. I tell everyone, research your lawyers, whoever it is that you are deciding to hire. Research them, sit down, discuss things with them, make sure that they are the right fit for you. Make sure that they have experience in whatever county that you have your case in, because you always have to know your audience, okay? Don't accept this as legal advice, but use it and try to do a little bit of good in the world, and maybe not make things so difficult on your spouse, ex-spouse, baby mama, whatever it is that she may be. And also, guys, thank you so much for joining me today. Y'all did awesome.